Jai Hind friends, firstly let me thank you for following this series with the motivation to be able to help you learn more about India's system of governance. We shall be completing 200 questions in this video. Thank you. And let us take 10 more questions to learn more. As always, keep your copy of the Constitution of India handy for reference. Please pause the video after every question, mark your own answer and only then proceed to listen. You can get all these questions at one place as a quiz and in PDF on the Telegram channel. The link is in the description of the video. And do not forget to keep looking at the parallel learning on each slide in the form of some pictures and trivia on the right hand side. Make note of it if you feel like and spend 2-3 minutes later reading about it online. So let's see the first question. Which of the following statements is or are correct? The date when the Prime Minister or the Chief Minister shall prove their majority in the lower house after taking the oath of office is decided by the President or the Governor, depending on which case it is. And that is absolutely correct statement. Sometimes I see people get confused because you will see the court may have given a direction, right? Or a confidence motion is brought in or a no confidence motion is brought in when the speaker may decide. So all those things are open, but possible. But court giving a direction doesn't mean it's their duty to do it, right? In cases where there is some malafide or some requirement comes up, the courts get into the picture. But essentially, when the oath is taken by the PM or the CM and the council along with them, then it is the President for Union and the Governor for the state who direct when the majority should be proved in the House. So don't get confused in that. Second statement says the mechanism of voting in the confidence motion, that is open or secret ballot, is to be decided by the Speaker of the House. And this is also a correct statement. Generally, you will see the convention has been that it goes with the open ballot. But as such, there is nothing specified in the rules as to it must be open. But generally, it is open ballot. In any case, technically, it is up to the speaker to decide that. So both of these statements are correct. And about half of you did get it right on the channel when the quiz was posted. So let's go to the next question. Which of the following statements are correct about the Lok Adalats in India? Okay, I'm sure you know that Lok Adalats have been created by the Legal Services Authorities Act of the year 1987, right? So it is a statutory provision. Hence the first statement, it is an extra constitutional and extra statutory mechanism, is actually incorrect. It is a statutory mechanism. That's the act. And then second statement says it is meant to settle disputes through conciliation and compromise. Yes, absolutely correct. And that is why the cases which are generally referred before the Lok Adalat are where some compromise is possible, right? So that is a correct statement. First one was wrong. And then third says it accepts the cases pending before regular courts except Supreme Court of India. No, it can be from any court. From all levels the cases can be taken up. So third statement is also wrong. And no appeal lies against the order. Absolutely correct. So the fourth statement is also correct. In fact, this is one of the conditions before the parties that when they take up the case to the Lok Adalat, they have to agree that this will be the final decision. So second and fourth are correct. I will recommend you go to the website of at least the NALSA and just read few more provisions about it, what is a National Lok Adalat and things like that. So let's move on to the next question. Which of the following are not mentioned in the Constitution of India? Motion of no confidence, I'm sure we all know that it is not mentioned in the Constitution. It is actually from the rules of the House in Lok Sabha. Then tenure of office of the Attorney General. Actually, there is no tenure at all. There is no term of office. So in the previous videos, I did recommend you to go to Article 76 and read about Attorney General. It says that the AG will hold office during the pleasure of the President. So actually there is no tenure in the office anyway. So this is also not provided for. Oath of the Speaker of Lok Sabha. There is no oath of the Speaker as such. The person who is elected as the Speaker of the House, or who's rather chosen as the Speaker of the House, takes the oath which any other member takes. So there is no different oath for the Speaker, so nothing is provided anyway. Then the President's address to a joint session of parliament after general election of Lok Sabha. Now this is actually provided for in Article 87 of the Constitution, and it very clearly says that there will be a special address by the President after the general election. You should know that originally it stated every session, okay? So now it states that the first session after every general election and the first session of each year. So this is actually provided for in the Constitution, and since the question is asking not provided, so the correct answer should be 1, 2 and 3. So less than half of you got it right. Well, now you know better. So taking the next question, the phenomena of coalition governments was brought by the 4th general election of 1967. SVD government became very popular. And what is this SVD? If you have read your NCRTs, especially the class 12th, Politics in India Since Independence, you would know that it's actually the short form for Sanyukta Vidhayak Dal, which is the United Legislators, team or front or group. And the elections of 1967, it did bring into the picture of phenomena of coalitions. And since no single party had got majority, various non-Congress parties came together to form joint legislative parties, and that is what was in those days referred as the Sanyukta Vidhayak Dal. So it's a straightforward question there. So let's move on to next question. Under Article 143 of the Constitution, when the President of India refers a matter to the Supreme Court for advice. So if you have not read Article 143, I will recommend you please read that now. You can pause the video, read and then come back. If you see there, as per clause 2 of the article, for issues related to any treaty, agreement, etc. that was executed before the commencement of the Constitution, it is necessary, it is bound, Supreme Court is bound to report its opinion to the President, right? So when it says Supreme Court is bound to give an advice, for issues other than what I just mentioned, it is not bound, but for the pre-constitutional treaties, agreements, etc., it is bound. So as a general statement, this is hence incorrect. So if you read further in clause 1 of Article 143, you will know that as such, in Article 143, the opinion of the Supreme Court is not necessary. Then secondly, it says President is not bound to accept the advice given by the Supreme Court. Absolutely correct. It's not binding on the President. It's not binding on the government. They may still go ahead and take a decision. It's just an opinion of Supreme Court. But later there may be cases, etc. So that's another thing. So anyway, second statement is the only correct statement out of these. Make sure you have read Article 143 here. Because less than half of you actually got it correct. So let's move ahead to the next question. Which of the following statements are correct? In all the occasions of a joint sitting of both the houses of parliament so far, decision has gone in favor of Lok Sabha. Otherwise also I'm sure you would have guessed that by the sheer strength of the Lok Sabha, which is almost more than twice of the size of Rajya Sabha, the numerical strength is always in the favor of Lok Sabha. But it's definitely not necessary, it will always happen like that. But yes, so far it has happened. I'm sure you know that the joint sitting has happened on 3 occasions. The Dowry Prohibition Bill of 1961, the Banking Services Commission Repeal Bill of 1978, and the most recent one was regarding the POTA, Prevention of Terrorism Bill, which became an act in the year 2002. So yes, it has gone in the favor of the Lok Sabha. Then no private member bill has ever been passed in the Parliament of India. This is incorrect. In fact, to tell you a fact, 14 private member bills have become an act so far, though nowadays it's a rare thing to see. So the last time it happened was in 1970 year when it was passed the last time. I would recommend you Google and see just quickly, in half a minute, which are these 14 private member bills. It will help you understand something more, which is a very disputable question coming up in the later questions, that can a private member introduce a money bill or not. So you'll get some ideas there also about that. Anyway, second statement is wrong. So we go to the third one. It says presiding officer of the House is the final authority in matters of regulating the business of the House. That is an absolutely correct statement. The final authority is the presiding officer. That's their work. Also, if you read Article 118 of the Constitution, it says that the rules are to be made by the House, and in the absence of the rule, it is the presiding officer who may decide on the issue at hand. So 1 and 3 are the correct answer. Oh, good. 2/3 of you got it correct in the quiz. All right, so the next question we have here is which of the following principles are a part of the principles of Panchashil? I'm sure you know these are the five principles. That's why the name Panchashil here. 5 principles of peaceful coexistence, and these were codified in the agreement between India and China in 1954 and was adopted at the Asian Prime Ministers Conference in Colombo. The principles were emphasized by Jawaharlal Nehru and the Chinese Premier Zhou Enlai. These are also considered as partly the principles for the Indonesian state, as was proclaimed by the first President Sukarno. So these 5 principles, a simple Google search will also tell you, these are mutual respect for each other's territory and territorial integrity and sovereignty, mutual non-aggression, peaceful coexistence, mutual non-interference in each other's internal affairs, equality, and cooperation for mutual benefit. As such, the non-alignment is not one of the principles, though these principles did form the basis of the non-aligned movement later, the NAM later. So it did contribute in that, but as such in the Panchashil you don't have non-alignment as such. Okay, so definitely some of you need to sort out your basics. This is a very straightforward question. If it comes in exam, you should all be getting it right. There is no reason to be confused at all. Okay, all right. So the next question we have is which of the following territories were integrated into India on the basis of plebiscite? I'm sure you know plebiscite, where the political future of the people is put to vote by the people. For example, in this case, what we are meaning to ask is that when the people of that territory decided whether they want to join India, the Union of India, or they want to join the Union of Pakistan after the independence was declared. So if you see, Punjab or Northwest Frontier Province, see Northwest Frontier Province you can immediately remove because yes, there was a plebiscite, but it chose to join Pakistan, and it is one of the provinces of Pakistan today. There was no plebiscite as such in Punjab. In Assam, the whole of Assam, there was no plebiscite, but in one district, that is the Sylhet district, there was a plebiscite, and Sylhet decided to go to Pakistan, actually East Pakistan at that time. So in Assam also as such, the whole of Assam, there was no plebiscite. Manipur was also a princely state where the ruler's decision led to the integration with India. So there was no plebiscite in Manipur as well. So actually none of these options are correct. Another important territory where plebiscite was conducted was Junagadh. I'm sure you know about that more from your knowledge of history. So next question that we have here is which of the following statements are correct regarding a motion of no confidence in the Lok Sabha? A very kind of question where a lot of debates happened, I see on the channel and the discussion group which used to exist till now, and the performance also was not extraordinarily high. So let's take these options one by one. First statement says it can be brought in the House only once per session. There is no such requirement in the Constitution or in the rules. In fact, no confidence motion is not in the Constitution itself. There is some other confusing part I see sometimes in the books and journals and online posts that the time has to be of minimum 6 months gap between two motions are introduced, two no confidence motions are introduced in the Lok Sabha. Now there is no such requirement as well. If you see the rules of the House, now you don't have to really see the rules of the House, I'm here for that. Understand this, that there is no restriction. You can bring as many no confidence motions in the House. The only condition is that the grounds must be different. Okay. You cannot bring two motions in the same session on the same ground. So if one ground has been taken up, the ground has to be different. Okay, so there is no restriction as such otherwise. This is actually a wrong statement. Then it says no such motion has ever been passed. This is perhaps the main issue of debate that I saw was happening. Absolutely correct. No such motion has ever been passed. Just to tell you some facts, only 3 prime ministers, okay, only 3 prime ministers of India have ever resigned due to lack of confidence proved in the House. One was VP Singh in the year 1990, then HD Devegowda in the year 1997, and Mr. Atal Bihari Vajpayee in the year 1999. But all 3 had resigned on the defeat of a confidence motion. Mostly what happens in the news, etc., people are not really able to differentiate between a confidence motion and a no confidence motion. So the end result would be either the resignation of the government or not, but confidence motion is what is brought by the ruling party. No confidence motion is what will be brought by the opposition who want the council to resign. Okay, so all these 3 resignations happened after the confidence motion was defeated. On all the other occasions, for example, Charan Singh in 1979 and Mr. Vajpayee again in 1996, the prime ministers resigned before facing the vote in the House. So because they knew in advance that the no confidence motion will pass, they resigned in the beginning itself. This is exactly what you saw that happened in Madhya Pradesh also last year. That the chief minister just comes and resigns because they know, or before that in Maharashtra and Karnataka, they know that they are not able to prove, so they resign before that itself. The no confidence motion actually never was passed in Lok Sabha. Then it says it need not set any grounds on which it is based. I already told you that there is no requirement to have a ground, but the condition is that if another motion is to be admitted, the ground has to be different. But it's not necessary to have a ground. It has a lower precedence than the confidence motion. Yes, absolutely correct. Confidence motion has higher precedence in the House. You should also know that the highest precedence among all the types of motions in the House is the motion of thanks to the President's address. So the highest priority is the motion of thanks to President's address. When a motion of thanks is pending, it takes over, it overrides all the pending business in the House. So, as I said, the performance was not that great. I hope you have learned something here about partly post-independence Indian history as well. So, we move to the last question today. Which of the following is or are extra constitutional methods for securing cooperation and coordination between the states in India? Zonal councils, I'm sure you know zonal councils were created by the States Reorganization Act of the year 1956, which created 5 zonal councils. There is one more council which people tend to confuse with zonal councils, but it is not a zonal council as such. It's called the Northeastern Council. It is also a statutory body under the Northeastern Council Act of 1971, but you have only 5 zonal councils as such under this act. And of course, the purpose is to bring a spirit of cooperation and coordination among the states in that particular zone. In fact, it's a very popular statement of Jawaharlal Nehru when he introduced this idea of zonal councils under the States Reorganization Act, that it is to promote the spirit of cooperative working. So the second one says governors conference. Yes, absolutely, all the governors participate here, and definitely it's a fora for cooperation, etc., and it is extra constitutional mechanism. This governors conference is actually slightly important because the 50th edition of this conference was held in November 2019 at the Rashtrapati Bhavan, and 5 key areas of emphasis were discussed. I would recommend you go and find out which were those 5 areas which were discussed here. This is the year of exam, and you should be aware. Okay, now the Interstate Council, it is also a platform for cooperation and coordination between the states. The name itself tells you that, but it is not an extra constitutional body. It is provided through Article 263 of the Constitution. Hence, this is not the option that we should be marking. So only 1 and 2 should be the correct answer for you. In the spirit of the learning that you have been getting alongside in terms of all these great people who received the Nobel Prizes, they were Indians or Indian American, Indian British Americans, some Indian origin. Many times in our lives we feel lost, we feel where are we heading, where are we right now, what are we supposed to do. and that disturbs us. So I thought I'll leave you today with this Japanese concept for happiness, which is called ikigai, and if you translate it, simply means a reason for being. Why do we exist? So this is a very beautiful depiction of your search for your ikigai, and it's the perfect culmination of the various aspects which we seek to achieve in our lives. So you can pause, read more, think about it, and that's it for today. I'll meet you with another video, and we'll discuss 10 more questions. Till then, study well. Thank you very much.